Hello and welcome to today's webinar presented by the ABLE National Resource Center titled Medicaid and ABLE, a look at the recently released CMS guidance. Before we get started today, I just want to cover a few slides on some housekeeping measures. The audio for today's webinar is being broadcast through your computer. Please make sure your speakers are turned on or your headphones are plugged in. You can control the audio broadcast via the audio broadcast panel. If you accidentally close the panel, you can reopen by going to the Communicate menu at the top of the screen and choosing Join Audio Broadcast. If you do not have sound capabilities on your computer or would prefer to listen by phone, the phone number and information is on the right hand of this screen and should have been in the WebEx confirmation email you received when you registered. Real-time captioning is provided during this webinar. The captions can be found in Media Viewer Panel, which appears in the lower right-hand corner of the webinar platform. If you want to make the Media Viewer Panel larger, you can minimize other panels such as chat, Q&A, and/or participants. Please use the Q&A box to submit any questions you have during the webinar, and we will direct those questions accordingly during the Q&A portion of the webinar at the end. If you are listening by phone and not logged into the webinar, you may ask questions by emailing questions to kausenbach@ndi-inc.org. Please note that this webinar is being recorded and the materials will be placed on the ABLE National Resource Center website at the following link. If you experience any technical difficulties during the webinar, please use the chat box to send a message to the host NDI admin, or you can use an email to, again, kausenbach@ndi-inc.org. Okay. Today's presenters include myself, Chris Rodriguez, Director of the ABLE National Resource Center, Marty Ford, Senior Executive Officer in Public Policy for the ARC of the United States, Morris Klein, who is a Fellow at the National Academy of Elder Law Attorneys, and Kathleen McGrath, who is the founder of KF McGrath LLC and the former Director of the Pennsylvania ABLE Program. On the agenda today, we will be discussing giving a brief basic understanding of ABLE so that everybody's on the same page when we dive into some more of the substantive information about the guidance recently released by Medicaid. So that will include ABLE history and basics. After that, we're going to dive into the actual Medicaid guidance itself, giving an analysis and a brief summary of the different areas that the letter concerns itself with. We will then move on to a couple brief slides about the ABLE National Resource Center. We'll cover some questions and answers with our panelists, and then release some information regarding a ABLE congressional briefing that will be taking place in early December. Okay. Let's go ahead and get started. I wanted to briefly, before we get again into the substance of the Medicaid guidance, we want to make sure that everybody's kind of has a jumping point or has some basic understanding of ABLE. So we're going to start with a couple slides related to the history of ABLE. So what is ABLE? ABLE is the Stephen Beck Jr. Achieving a Better Life Experience Act that amended the federal tax code to add section 529A. And what it does is it creates a new option for eligible people with disabilities to save money in a tax-exempt account that can be used for what's called qualified disability expenses while keeping their eligibility for federal public benefits. Now, there's a lot of kind of loaded terminology within that statement, and we're going to kind of dissect what each of those terms means, including exactly who is eligible for ABLE, what exactly is a tax-exempt account, what are qualified disability expenses, and what specific federal public benefits are excluded when determining eligibility with respect to the funds in an ABLE account. Okay, so again, a little bit about the history. Where did this idea come from? It really came from a group of parents sitting around a kitchen table with the idea and wondering why they could not save for the future of their son or daughter with a disability without putting in jeopardy their federally funded means-tested benefits such as Social Security and Medicaid that provide essential benefits, supports and benefits that help those individuals maintain independence in the community. So they came up with this idea about ABLE. ABLE spent nearly a decade going through the legislative process within Congress. It was supported and had an incredible amount of advocacy from local, state, and federal advocates across the country. ABLE became law in December of 2014, and by the time it made its way to the President's desk, it had overwhelming bipartisan support in both the House and the Senate. It's important to note that what the ABLE Act does is it authorizes states to establish ABLE programs, but it does not mandate them to do so, nor does it actually give them any resources to help them get up and running. That being said, I'm happy to report that we've seen 28 different states launch ABLE programs providing the benefits related to ABLE for eligible individuals with disabilities to save for their futures while maintaining their eligibility for most federal benefits. With that, I want to turn it over to Marty Ford, who's going to get into a little bit of the details about some of the components related to ABLE.
Thank you, Chris. And as Chris said, I'm going to go over a lot of details or give you an overview of it for those of you who may be coming to this for the first time or just new to this program, so that you'll have some basics when we get back into the purpose of this particular webinar. So first of all, some of the basic characteristics of the program are that there are eligibility requirements before you can open an ABLE account, and they deal particularly with the age at which the person first became disabled, and there are some requirements regarding the severity of the disability, and I'll get into that detail in a minute. And an individual is not obligated to enroll in a program in their state of residence. You can open an account in another state if you choose. And the designated beneficiary is the account owner. And another person, however, such as a parent, a guardian, or a person with power of attorney, can be allowed signature authority over the account. But the designated beneficiary is the account owner, and that is a bit different from the way the college savings plans work. The funds in the account may be used for qualified disability-related expenses only. And the assets in the account and the distributions from the account for those qualified disability-related expenses will be disregarded or given special treatment when looked at for eligibility for federal means-tested benefits, including Social Security and Medicaid, and I should say SSI is included when we talk about Social Security. And anyone, basically multiple individuals, anyone can make contributions to an individual's ABLE account. Currently, and I mean this year, until the end of this year, there's a $14,000 annual contribution limit. That contribution limit goes up in 2018 to $15,000. But that is for all contributions combined, coming from all sources. So who is eligible to be an ABLE account beneficiary? Let's get into details on those requirements. First of all, the age requirement, which many of us are working on to try to increase right now, you must be disabled before the age of 26. Secondly, there is a level of severity of disability that you have to meet. And there are two ways of meeting that. The first is to actually be eligible for the Supplemental Security Income, or SSI, program, or the Social Security Disability Benefits programs within Social Security. You must have been determined to meet the disability requirements for that program. Or you could submit a disability certification that says that you have documentation of a physician's diagnosis and a signature from the physician that confirms that you meet the functional disability criteria of the ABLE Act. And that is essentially related to the level of severity of disability that is required to meet the SSI or the Social Security disability programs that I mentioned earlier. And if you have questions on that, we can cover that in detail during the question period. But those are the two ways of doing it. Either you're currently receiving benefits or have been determined to meet the disability requirements of the programs, or you can get a doctor's certification and a signature that says, yes, you meet that level of severity of disability, and you have the age limit. What can funds from an ABLE account be used for? Again, distributions from an ABLE account may be made for what's known as qualified disability expenses. And those qualified disability expenses are expenses that have to meet certain criteria. They have to relate to the designated beneficiary's blindness or disability, and they have to be for the benefit of that designated beneficiary or the owner of the account in maintaining or improving his or her health, independence, or quality of life. Sounds limited, but actually if you think about that being federal legislative or regulatory language, that's pretty broad and remarkably progressive. It has to be used for maintaining or improving his or her health, independence, or quality of life. And the qualified disability expenses are supposed to be broadly construed to permit the inclusion of basic living expenses and should not be limited to items that for which there's just there's a medical necessity. That's something that we have dealt with in the past and been very problematic in other programs, and also should not be limited to items or services that just benefit the eligible individual, where there might be some peripheral benefit to somebody else. That particular description, those last 3 points came from the regulations, and that also, I believe, we all consider to be fairly progressive. The fact that the basic living expenses was added by the regulations, and the fact that it's not limited just to medical necessity, and that there cannot be any other benefit to someone else is a progressive thing, because we have had problems with that in other situations. That there is a recognition that often what an individual uses or a service to an individual will have some peripheral benefit to other people, and so that will not exclude that expense. So qualified disability expenses may include the following, and I'll just read you the list: education, housing, transportation, employment training and support, assistive technology, personal support services, health prevention and wellness, financial management and administrative services, expenses for oversight and monitoring, legal fees, funeral and burial expenses, and then, as I said, the basic living expenses that were added by the, actually by the proposed regulations. And then the law also says, and any other approved expenses approved by the Secretary of the Treasury through the rulemaking process. And that's very important, because that's essentially what the Secretary did by adding basic living expenses. And so it's open for other things to be added in the future. The distributions for things that are not approved on the list will be subject to tax consequences and might affect eligibility for federal means-tested benefits. And so that's something that people need to realize. If it's not on that list, or if people can't make a reasonable claim that what they've spent their money on would fit under one of those categories, then they have to be prepared for the consequences. How do ABLE account assets impact eligibility for federal benefits? The critical thing here is that ABLE assets will be disregarded or receive favorable treatment when determining eligibility for most federal means-tested benefits. And I'll have to say the advocates here are the ones who put the word most in there. The statutory language is pretty clear that it's for all federal benefits. I think we're being a little careful because we don't have regulatory or guidance language from all of the federal agencies yet that handle all of the programs that people care about. And so we're trying to be extra careful before we give out information. But the purpose of this call is to give you the information about the Medicaid program. We've already got incredible information about the SSI program. So we just don't want to go beyond what we think we can give you. But essentially, ABLE assets are intended by the law to be disregarded for federal means-tested programs, except, and the law has a big exception here, for the SSI program, it's only the first $100,000 in an ABLE account will be disregarded. Now, for those of you who know that the SSI program has a $2,000 resource limit for individuals, talking about the first $100,000 being disregarded is a pretty remarkable statement in itself. If you have $100,000 in an ABLE account and go over that, then SSI payments, meaning the monthly cash benefit, will be suspended but not terminated if the account goes over $100,000. But SSI benefits or eligibility will not be terminated, and that's really important. So if the funds in the account then drop down below $100,000, your SSI cash payments will be reinstated. And the importance of having the daily living expenses added to the list of allowable expenditures is that if your monthly SSI cash benefit stops, you can use the funds in your account to pay for your food and your daily living expenses, and then they may drop, your account may drop below $100,000, and then your monthly payments will start again. So that's an important thing to remember. Funds above $100,000 will be treated as resources, and then there's even there still a little bit of room because remember there is that $200 resource limit for individuals and $2,000 resource limit for individuals and $3,000 for couples. Then to continue on that, looking at Medicaid, here there is some confusion because people hear what happens with SSI and they believe it's the same for Medicaid, but actually ABLE assets are completely disregarded in determining Medicaid eligibility. So that $100,000 limit on SSI being disregarded is not the case for Medicaid. ABLE assets are completely disregarded for Medicaid. Medicaid benefits are not suspended if the ABLE account exceeds $100,000. That's only for SSI. However, there is what's known as a Medicaid payback if there are funds remaining in the ABLE account when the individual dies. And those funds would be subject to this Medicaid payback to the extent that once any outstanding qualified disability expenses are settled. So if there's anything that's still owed to anyone or to a vendor or whatever for qualified disability expenses, once everything else is settled out and funeral expenses paid, et cetera, that those funds can be used to reimburse a state for Medicaid payments made on behalf of the beneficiary after the creation of the ABLE account, not for any Medicaid expenses before the account was created. The state would have to file a claim for those funds. Some states are actually choosing not to pursue this payback, and I think we might hear a little bit more about that later, possibly. And the CMS letter that Chris is going to be talking about later does raise an issue regarding a state recovery for people 55 and older. But for the vast majority of people right now, this does have some limitations on it. I do make the distinction between SSI and Medicaid here, but for practical purposes, if for many people, if you're limited by the SSI limitations, that's probably going to mean that the individual is limited regardless, because, you know, they may be using Medicaid, but the SSI is what causes the limitations for them. But still, there's $100,000. So tax treatment on ABLE accounts. Contributions to ABLE accounts are made with post-tax dollars or after-tax dollars, and ABLE account earnings grow tax-free and are tax-exempt. Now, this is all about federal taxes. What happens at the state level? Because this is federal law, and the federal government cannot tell the states whether they can tax or not tax. Some states have decided to go ahead and offer tax advantages or deductions for contributions made to ABLE accounts by their in-state residents. And let me tell you which ones they are. Iowa, Maryland, Michigan, Missouri, Montana, Nebraska, Ohio, Oregon, Pennsylvania, apparently the newest one last week, South Carolina, Virginia, and Utah allows a credit as opposed to a deduction. And then Wisconsin, which apparently does not have an in-state ABLE program, all of its residents who use ABLE would be using out-of-state programs, but it offers a tax deduction in-state. So that's a remarkable approach, which is great. And then just to let you know that ABLE accounts, ABLE programs have been launched in 28 states and growing. And there are several that are nationwide and some that are in-state only. And for those who may need me to do so, I'll go ahead and read the list off. The states that offer nationwide programs: Alabama, Alaska, Colorado, Kansas, Indiana, Illinois, Iowa, Massachusetts, Michigan, Minnesota, Montana, Nebraska, Nevada, North Carolina, Ohio, Oregon. That's a nationwide option for non-residents. Rhode Island, Pennsylvania, Tennessee, Virginia, and Washington, D.C. Then there are in-state programs which are limited to in-state residents only in Georgia, Florida, Kentucky, Louisiana, Missouri, New York. Oregon has an option for in-state residents also, and Vermont. I believe some of these states are planning to eventually expand to out-of-state, but they haven't yet. And the programs, some of the programs are run in a consortium, and therefore their plans are very similar. But if people are choosing to go out-of-state, there are lots of differences among the plans, and people can go online and look at those differences. There are different kinds of fees. There are different ways of accessing accounts, all different aspects of the programs that they got to look at and compare when choosing and including what the total amount is that you can keep in an ABLE account. And I will now turn it over to Chris to talk about the next topic.
Okay, thank you very much, Marty. I appreciate giving that perspective in terms of letting everybody know kind of the ABLE basics, things that are going to be consistent across all programs. That way we have a little bit of a foundation as we go into some of the more detailed information as it relates to this guidance that was recently released from CMS. So, the Center for Medicare and Medicaid Services, or CMS, recently released what's called a State Medicaid Director Letter, or SMD, number 17-002 on September 7th of 2017, titled Implications of the ABLE Act for State Medicaid Programs. So what is the purpose of a letter like this particular letter? Well, this letter provides guidance to states on the treatment of funds in, contributions to, and distributions from an ABLE account under Section 103 of the ABLE Act for purposes of Medicaid eligibility. So it's important to note, while we talk about all the different ways that ABLE funds both, again, contributed and earning interest in the ABLE account and distributed, and when we speak to eligibility, we're just talking about, at least for this webinar, just eligibility to the Medicaid program. CMS does not have the authority to determine who is eligible and how ABLE funds affect, let's say, Section 8 housing, because that would be under HUD, or Housing and Urban Development. Additionally, the letter also addresses the treatment of funds in an ABLE account for purposes of the post-eligibility treatment of income and the disposition of amounts remaining in a Medicaid beneficiary's ABLE account upon the death of the beneficiary, or what Marty described as the Medicaid payback provision. So we're going to go into greater detail about that. The letter breaks itself down into 6 areas of focus. The first is background, followed by eligibility to participate in a qualified ABLE program, treatment of funds in an ABLE account, contributions to an ABLE account, distributions from an ABLE account, post-eligibility treatment of income, and lastly, transfers of ABLE account funds to state and estate recovery. So that, again, is that section that Marty talked about, which is referred to as the Medicaid payback provision. Okay, so let's talk about the background section that is in the CMS letter, and this is information that is coming from CMS that they want to make sure is clear to their state directors, their state offices. So they let them know, and they acknowledge, and they back up the fact that the purpose of the ABLE Act is to permit people with disabilities to save money in and withdraw funds from their ABLE account to pay for disability-related expenses in support of their efforts to maintain health, independence, and quality of life. And what we're really looking for here as we kind of go through letters of guidance, this one specifically CMS, is that they correspond with the intent of the law and with, to the greatest extent possible, the language of the actual statute of the ABLE Act, because that's really where they should be kind of siphoning their instructions from. Additionally, CMS acknowledges that the law states that the ABLE accounts should supplement but not supplant benefits available to ABLE account beneficiaries under Medicaid, the Supplemental Security Income Program, or SSI, and other programs. Now, this is incredibly important because we wanted to make sure that just because an individual has what could be considered significant resources within an ABLE account, that just because they have those to pull from, that other benefits related to other programs aren't diminished as a result. And that's really where we pull that from in terms of how these funds should supplement but not supplant various benefits, and they acknowledge that, and they include Medicaid in that, which is great. They go on to state that Section 103 of the ABLE Act provides that for the purpose of determining an individual's eligibility to receive or the amount of any assistance provided by a needs-based federal program, such as the Medicaid program, amounts in, contributions to, and certain distributions from ABLE accounts shall be disregarded. So again, it's backing up the intent and how we as advocates have advocated for the law and how the law was written, and it's fairly consistent with other guidance we've seen through other federal agencies such as Treasury and such as Social Security. So we're seeing a lot of continuity, and that's a good thing, right? Okay, so going into the next section, and the background is really just laying down for the Medicaid directors an understanding of the direction and the intent and how CMS is interpreting what has already been established under law. So then they go into some more detail, and this section talks to the eligibility to participate in a qualified ABLE program. And what this section does is it reiterates who is qualified to open an ABLE account and thus is eligible for the benefits or treatments that are associated with being an ABLE account owner, including those having to do with treatment of funds by a Medicaid program. So they're just making sure that people understand who is allowed to have these benefits associated with being an ABLE account owner with respect to Medicaid eligibility. Because if you're not eligible to have an ABLE account or be an ABLE account owner, then you're not going to be allowed to have the benefits that are going to be described in this letter whatsoever, so they wouldn't apply to you. Additionally, Medicaid or CMS wanted to reinforce the fact that there should be no inference in terms of the disability certification towards eligibility for Medicaid. So basically what that is saying is just because an individual has an ABLE account and may be legitimately eligible for an ABLE account, that does not necessarily mean that they're automatically eligible for Medicaid benefits or to be a Medicaid beneficiary. So that's important to note. And it's important to note that not all ABLE account owners will be receiving Medicaid benefits, so that they're not interconnected like that for purposes of eligibility. Additionally, it states that state Medicaid agencies should presume that an ABLE program established by a state is a qualified program in the absence of evidence to the contrary. So they just basically wanted to make sure, because a lot of the provisions within the law are allowed to individuals who are quote-unquote enrolled in a qualified program, they wanted to make sure that folks understand exactly what a qualified program is, because again, if a person somehow was enrolled in a non-qualified program, they would not be allowed the benefits that are associated with this particular guidance. So they just wanted to clarify a few different things. The next section talks to the treatment of funds in an ABLE account, and this shouldn't really come by as a surprise to anybody, because these are things that we've talked about in many of our presentations previously, but it is important that Medicaid or CMS specifically reinforces what we've already found to be true. So it states that state Medicaid agencies must disregard all funds in an ABLE account in determining the resource eligibility of Medicaid applicants and beneficiaries who are subject to a resource test. Again, this should not be unusual language to folks, because these are things that we obviously had gleaned from the actual statute. But again, it's incredibly important that CMS reinforce these and make sure that their state Medicaid agencies are aware. Additionally, it went further, saying that their earnings on the account should also be excluded from income for when determining eligibility into a Medicaid program. So not only are the dollars that sit inside an ABLE account, of which we know that they're really being invested, the money that is accrued as a result of those investments is not counted as income when determining eligibility for that Medicaid beneficiary. So that's important to note. So not only the funds inside the ABLE account, but also any funds that are are the interest of that principal that's in there, those are not counted as income, which could, in other circumstances, affect an individual's eligibility for the Medicaid program. So the next section talks about contributions to an ABLE account. So basically lets Medicaid state programs understand how they should be treating contributions into somebody's ABLE account. So it states that third-party contributions to an ABLE account, so that could be a sibling, a parent contributing into their family member's ABLE account, those are disregarded as income or a resource in the following month if not spent when determining Medicaid eligibility, including contributions from a special needs trust or a pooled trust. So this is interesting. If you did not have the protection of an ABLE account and an individual was just to, let's say, write a check to an individual who's a Medicaid beneficiary, that check could be counted as income to that individual, and thus be taken into consideration in maintaining their eligibility for Medicaid. So what this says is that is not the case when contributing into an ABLE beneficiary's account. And this goes even further, saying that not only is it third-party contributions, but the same type of benefit is offered under the circumstance that the funds are being contributed from that individual special needs trust or pooled trust. So I know I get a lot of questions about, is it allowable to transfer funds from a special needs trust into the beneficiary's ABLE account? That, for purposes of Medicaid eligibility, shores that up, saying that yes, it is, and it will not interfere with the beneficiary's benefits under Medicaid. Additionally, the designated beneficiary of an ABLE account can contribute their own income or resources to their ABLE account. If an ABLE account beneficiary transfers some of his or her own otherwise countable resources to his or her ABLE account, the effect would be a corresponding reduction in total countable resources. So a lot of people that are on the phone might be very familiar with the idea of a spin down. In many circumstances, people with disabilities who are either perhaps on SSI or Medicaid or another means-tested benefit have to get rid of funds in a very short period of time to maintain their eligibility, and it's referred to as spin down. In these circumstances, if an individual needs to get rid of resources, they can transfer those resources into their own ABLE account, so make a contribution from the beneficiary into the beneficiary's ABLE account in order to reduce those resources so that they can maintain eligibility, in this circumstance, for Medicaid supports and services. That being said, the next part is very important. By contrast, if a beneficiary of an ABLE account transfers some of his or her income in the month received to his or her own ABLE account, the effect would not be a reduction in countable income. So we're going to get into this a little bit towards the end when we talk to the panel, but the two things that you're going to want to concentrate when maintaining eligibility or getting eligibility for Medicaid is income and resources. What ABLE does is it helps protect resources. It gets around the resource limit. It does not protect income made by the beneficiary, even if that beneficiary is earning that income and putting it straight into the ABLE account. It still is counted as earned income and thus can still be taken into consideration when determining eligibility for, as this letter states, their Medicaid eligibility. So that's important. It's an important differentiation to make. Lastly, under this particular section of contributions to an ABLE account, this next part is actually pretty important and something that I don't think has been given a lot of thought or attention, and I'm glad that it is addressed in this guidance because it clears up some questions that I know some folks in the National Advocacy group have been talking about. And it states that it is possible that a third party who has made a contribution to an ABLE account of someone else may apply for Medicaid and seek coverage of long-term supports and services. Section 103 of the ABLE Act does not provide any special treatment or benefits of contributions made to an ABLE account benefiting a different person. So what exactly does this mean? So let's use the example that's provided in the guidance. And that states that a contribution from, let's say, a grandfather to an ABLE account of his grandchild, whether from the grandfather's income or their resources, would constitute a transfer of assets from the grandfather to the grandchild's account, which may need to be evaluated under certain requirements of the Social Security Act, depending on when the transfer occurred. If the grandfather subsequently seeks Medicaid coverage of LTSS, which is long-term supports and services. So if the grandparent, for whatever reason, has an unfortunate circumstance related to their health and finds themselves needing Medicaid supports and services, specifically long-term supports and services, and has recently transferred funds into, let's say, their grandchild's ABLE account, there's what's called a look-back period so that individuals can't just give their money away in order to make them eligible for Medicaid, and those funds might need to be taken into consideration when determining the third-party contributors' contributions. And we'll talk a little bit about that later on with our panel to try and flesh that out some more and try to describe why that is a fairly important thing to understand. Next, the next section of the guidance is titled Distributions from ABLE Accounts. And this states that as long as distributions from an ABLE account are used for QDEs, or qualified disability expenses, as they were described by Marty earlier, of the designated beneficiary, they are not included as income for purposes of determining Medicaid eligibility. So that means they're going into even further, saying that not only, as we learned in the last section of the letter, that funds in an ABLE account are not counted when determining eligibility for Medicaid, and even interest earned on the money that's inside of an ABLE account is not counted as income and will not affect the person's eligibility. This one goes so far as saying distribution, so when the individual takes the money out of the ABLE account, provided that it's used for qualified disability expenses, those things that Marty described earlier, then it will not be counted as income when determining Medicaid eligibility. Now that being said, and this goes back and it gets in a little more detail, but was mentioned by Marty, is that distributions from an ABLE account that are not for qualified disability expenses and or distributions that exceed the cost of those qualified disability expenses do not fall within the scope of the protections afforded by the ABLE Act and may be countable as income with respect to Medicaid eligibility. So this goes back and this just reaffirms what Marty said earlier, but specifically to the Medicaid program, saying that if you use these funds inappropriately, they will not have the protection of the ABLE Act and thus may affect your eligibility for, in this circumstance, as CMS describes, for Medicaid eligibility. So you're going to want to make sure that you're using these funds appropriately, or there will be further consequences outside of just some tax implications. And that's something that we want to stress, that people understand how to use these accounts appropriately so that they don't lose, in many circumstances, very vital supports and services, in this case, again, provided by the Medicaid program. Additionally, states should continue to disregard ABLE account distributions retained after the month of receipt unless used for a non-qualifying expense. So what this basically talks to is it kind of shores up this guidance with guidance that we saw under Social Security, which means that even if an individual takes money out of their ABLE account and places it in a checking account, and the month moves forward, those funds are still not counted as a resource when determining eligibility for Medicaid unless those funds, again, are used for a non-qualified expense. Okay, so let's talk about the section titled Post-Eligibility Treatment of Income. So what exactly is post-eligibility treatment of income? Well, the requirement that affects individuals applying for most of their total available income to the cost of long-term supports and services before federal financial participation for medical assistance is available is referred to as post-eligibility treatment of income. Basically what this says is there are certain circumstances where before you're provided benefits under Medicaid, they will take a look at what types of resources you have available and take those resources into consideration when determining the amount of supports and services that they will give you through the Medicaid program, right? So what this guidance says is that for the purposes of that post-eligibility treatment of income, states should disregard from an individual's total income any ABLE account distributions that are used for qualified disability expenses. It also states that to the extent that a distribution is counted as income in determining the individual's eligibility for other Medicaid benefits discussed previously, the distributions also would be counted for purposes of PETI. So this goes back to the fact that not only are ABLE funds that are contributed into and held within an ABLE account and distributed for purposes of qualified disability expenses, not taken into consideration when determining just eligibility. They're also not supposed to be taken into consideration when determining the scope of benefits allowed to that, in this case, Medicaid beneficiary. So that means that if you walk in to get an evaluation for the various supports and services that you're provided through Medicaid, and a person tells you, well, you have $75,000 in your ABLE account, therefore we're going to decrease your number of such and such supports or services. What this CMS guidance says is that as long as you're using these funds appropriately, which means that you are in fact qualified to have an ABLE account and you're spending the money on qualified disability expenses, they are not allowed to do that. So that's something that's very, very important. There were questions before a lot of this guidance came out that we certainly understood for eligibility purposes that these funds would be protected, but there was a little bit of uncertainty whether or not they could decrease certain supports and services to an individual, and this says very clearly that they cannot. So that's a very important clarification that we now have in writing from CMS. Okay, so lastly is what's titled the transfers of ABLE account funds to state and estate recovery. And this part, at least to me, is probably gets most into the weeds and can be a little bit confusing. So just to go over and make sure everybody's aware of what section we're talking about, because we did discuss it previously, Marty described it, but I want to do it one more time. Section 529AF, which is the Medicaid payback provision within the ABLE Act, requires that certain amounts remaining in an ABLE account upon the death of the account beneficiary, subject to an outstanding payment due for qualified disability expenses, shall be distributed to a state that provides medical assistance to the beneficiary after the establishment of an ABLE account upon the filing of a claim for payment by such state. It goes on to, again, help Medicaid directors understand the payback provision, and it goes on to say, the amount that may be so distributed is limited to the excess of the total medical assistance paid for the account beneficiary after the establishment of the ABLE account. So it's important also to notice when I say medical assistance, we're talking about medical assistance provided through that state Medicaid program, not just medical assistance in general, but specifically to that. And that really is describing the Medicaid payback provision. Now what is important, and again, Marty touched on this a little bit, and we're going to be talking about with a couple of our panelists in a little bit, is that it acknowledges that the guidance that was released last year by the Treasury and IRS does not propose mandating the state file a claim. So this means that while the ABLE Act allows a state to file a claim for Medicaid services and supports provided to the ABLE account beneficiary, starting at the point in which they open the ABLE account after the person passes away, they're not obligated, at least in this interpretation, they're not obligated to do so. They don't have to do that, right? But it goes on to say, however, even in the absence of a Treasury and IRS mandate regarding those claims against an ABLE account pursuant to Section 1917B of the Social Security Act, states are required to seek recovery against the estates of certain deceased Medicaid beneficiaries. So there are other laws, and again, we're going to go into this in a little bit later in greater detail. There are other laws unrelated to ABLE that call for payback provisions, and you could be subject to those laws and be an ABLE account owner. So that's important to note. It goes on to say, one second. It goes on to say that, thus, consistent with the Social Security Act, states are required to seek recovery of funds in an ABLE account that have become part of an estate subject to recovery under other statutes. And this particular one, they're talking about the Social Security statutes. And this is really relating to people, that specific individuals whose estates state Medicaid agencies must seek recovery from, and those who receive Medicaid at the age 55 and older, or who receive coverage for certain long-term supports and services and were subject to the PETI rules. So what that's basically saying is, yes, the CMS agrees that states do not have an obligation under the ABLE Act to recover those funds if they choose not to, and we'll give an example of different states that have done that. However, the ABLE Act does not supersede other laws that require for a Medicaid payback if the ABLE beneficiary is also subject to those. Now, if the ABLE beneficiary is not, then and their particular state has decided through state laws that they will not file a claim, then they're good to go, then they don't need to worry about that. But it is important to note that even if they're living in a state that has decided not to file a claim, that does not supersede other parts of the Social Security Act that require payback under other circumstances. Furthermore, if the state of an ABLE account beneficiary is not subject to a Medicaid estate recovery, again, states have the discretion, like we said previously, whether to file a ABLE claim against the ABLE account of the deceased individual who had been enrolled in a Medicaid program. So we're going to talk about that a little bit more with some of our panelists, because I know that that can be confusing. And if anybody is interested, let's see here one second, in going and reading the specific language within the letter, we wanted to provide you with that in the following link. The following link will take you to a summary that the ABLE National Resource Center has done, but also provide you with the link to the very specific language in the actual letter, so basically a copy of the letter itself. So with that, I wanted to turn it over to another one of our guests today, Morris Klein, who practices law in Maryland and the District of Columbia. He concentrates in elder law, special needs law, and estate planning, because I want a bit of a comparison, because as many of you know, the ABLE Act or ABLE accounts are not the only vehicles for helping people with disabilities be able to save while maintaining their eligibility. Specifically today, we're talking about Medicaid. So I wanted Morris to give us an idea of how these regulations, or these guidance, I should say, I'm sorry, from CMS related to ABLE, how they compare to other tools, specifically a special needs trust, with protecting benefits and kind of the pros and cons of the two. So with that, I will hand it over to Morris.
Thank you, Chris. Thank you for asking me to participate in this program. So the ABLE law is a wonderful addition to the devices in a toolbox that is used to allow persons with disabilities to have use of funds without it being considered available for public benefits and necessitating a spend down. It's the maximum for SSI has been $2,000 almost forever, and the ABLE is a mechanism that would allow individuals who qualify to be able to have funds in excess of that and still receive the public benefits they would otherwise be receiving. So
Morris?
It's also, yeah.
Yeah, so just for the folks, I don't know that I did a very good job describing the term spend down, but if you want to let people know what you mean when you use that term.
Yeah, sure. So spend down means that for public benefits such as SSI and Medicaid, you're not allowed to have more than a certain amount of money and still qualify for the program. So SSI is a federal program, and the SSI rules say that you can't have more than $2,000 of countable assets. And if one has more than that, one has to, quote, spend down, unquote, their funds to get below that $2,000 number. Medicaid is a federal state program, and so the Medicaid spend down rules sometimes are different than the SSI rules. So if one doesn't need SSI and is getting Medicaid, for example, in the District of Columbia, the spend down is $4,000 for an individual. In the state of Maryland, it's $2,500 for an individual. So that's what I mean by spend down. These rules are complicated because, as I just mentioned, there are different public benefit programs that have different rules, such as Medicaid and SSI, and to a lesser degree, the housing rules and the rules for food stamps, et cetera. It's also complicated because each of the available ways to protect assets have their own little quirks and idiosyncrasies. One way to sort of think about this, to try to simplify it, is that the public benefit programs place a big deal as to the source of the funds. So generally, whether the funds are coming from the person with disabilities or somebody else, such as we call third parties, that's a big deal. And the bottom line is that if the funds are coming from someone other than the person who has a disability, there are fewer limitations and restrictions on the use of the funds. And there's sort of a broad definition of funds that are considered to be owned by the person with disability. If they inherit something, it's considered to be their money. If they're the beneficiary of a personal injury action where they were hurt and they get a judgment or a settlement, that's considered to be their money, as well as money that they may have been given before there was a determination of disability, like if a parent put something in a Uniform Trust for Minors Act account. That's all considered to be the person's own funds. However, if mother or father or uncle or aunt or anyone else in the world, for that matter, wants to set aside money for the person with a disability, it is not their funds, and it's what's called a third party's funds. And generally, the tool of choice, because there are fewer restrictions and limitations, is if the funds do not belong to the person with a disability, the tool of choice is what's called a third-party special needs trust. And in this little chart that's here that took up 2 slides, you can see that for a third-party special needs trust, there are no real restrictions other than the fact, and this is the critical thing, that the trustee has the discretion whether or not to make distributions. In another big distinction in the world of these trusts is to what extent the government can compel a distribution. So if the trustee is obligated to pay funds for some reason, then the government can say, well, if you're obligated to make a distribution, then you have to make the distribution, and it's available to the person who has the disability and therefore subject to the spend down. But if the trustee has discretion whether or not to make distributions, then the government can't force the trustee to make a distribution, and therefore it's not considered to be available. So the tool of choice when you're dealing with funds that are not sourced from the individual is this third-party special needs trust. The disadvantages of a third-party special needs trust is generally it has to be a customized document, and generally you have to pay to get the document created. That's generally the one disadvantage. The other advantage of a third-party special needs trust is that can be set up while the third party is living, or that can be part of their will. It can be made revocable, or it could be made irrevocable. There are lots of flexibility in setting this up. So if you're dealing with the person's own money, then there are other trusts that might be useful. The ABLE, as I said, is just a wonderful new method of protecting funds, but there are limitations that we already mentioned. The biggest is that the person with a disability has to be disabled before they turn 26. And so that does remove a significant part of the population who may require public benefits from getting an ABLE account. The other limitation, which somehow escaped my chart here, is that you can't contribute more than a certain amount each year, and that amount is the federal annual federal gift tax exclusion, which this year is $14,000, but is expected to rise to $15,000 beginning in January of 2018. There are some limits as to who can create the trust. For ABLE as well as the other trusts. So let me just sort of jump over and talk what the other alternatives to ABLE are if we're talking about funds owned by the beneficiary themselves or the person with disabilities. And the two are what's called a self-settled special needs trust and a pooled special needs trust. And these both date back to a law that was enacted in 1993 that I know Marty was involved in its formation, and we're indebted to Marty for having these laws on the books that do allow special needs trusts to be set up. A self-settled special needs trust is one where it's the person's own funds. They can only be established, however, by a parent, a grandparent, a guardian, or a court, and more recently, if the person is capable, by themselves. There, in most states, is a process where the states review the trust, and it's a whole production. Separately, there's what's called a pool trust, and a pool trust sort of operates the way a mutual fund operates, in the sense like a Vanguard or a Fidelity, where different people can put money into the account and all the money is invested and handled in the same way. The trustee is the one of the pooled special needs trust, is the one that makes the distributions. So as that is sort of a background, let me just sort of march through this chart so you can sort of see what some of the differences are. So if we can go back one slide to number 39. Yeah, thank you. So for ABLE, anyone can fund the account once it's established. For a third party, anyone but the beneficiary can fund it. For the self-settled and for the pooled special needs trust, it should be funded mainly by the beneficiary's own funds because there are better ways to fund third-party money. The restrictions are for ABLE, as I said, you have to be you have to be disabled under 26, and there's a limit as to how much money can be contributed. There is no restriction for the third party, assuming that the money is not the disabled person's money. For the self-settled special needs trust, you cannot fund it after the beneficiary reaches the age of 65, or it can't be created after also if the person reaches the age of 65. Pooled special needs trust, if you're getting SSI, is the same as self-settled. Once you turn 65, that's it. For Medicaid, in some states, you can make contributions or establish it after you're 65. The issue for Medicaid is whether or not the funds that are used to put into the trust are what's called a gifting of assets, which could delay Medicaid eligibility for a period of time. Maryland, for example, doesn't have that limitation. Virginia does have that limitation, for example, so it's on a state-by-state basis. As far as who establishes these trusts, there are limitations that Chris mentioned for ABLE, and I mentioned a few minutes ago for the pool trust and the special needs trust. They can be established, all of them, during the beneficiary's lifetime, and in addition, for the third party, for a grandmother, for example, can put it in her will that she wants a special needs trust set up for the benefit of her grandson who has a disability. A big difference contrasting pooled special needs trusts with the other is who is the trustee. That is the person who decides when the money comes out. For an ABLE, it could be the beneficiary themselves if capable. For the third party, it can never be the beneficiary. For a self-settled special needs trust, it can never be the beneficiary. It could be anyone else. And uniquely for the pooled special needs trust, it's the company itself. It's the organization that sponsored this pooled special needs trust that serves as the trustee. Some people think that's a good thing because they don't want family members, for example, to be bugged by the person who's the beneficiary, keeps asking for money. It can be the responsibility of the pooled trust. Others don't like it. They want the control of somebody in the family to be the beneficiary. Moving on to the next slide, for an ABLE account, only the beneficiary can be only the individual disabilities can be a beneficiary. For a third party, actually that's wrong. It's only the beneficiary could be I'm sorry, that is correct. The third party, only the beneficiary and anyone else can be the beneficiary of the trust. What's incorrect is the next cubicle. Only the beneficiary can receive funds from a pooled special needs trust. It has to be for their sole benefit, as is for the pooled special needs trust. The advantage of ABLE and the pooled special needs trust, there are documents already available. You just fill out some forms and you're done, whereas for third-party special needs trusts and self-settled trusts, you do need generally customized documents. And the other advantage of the third party, in contrast to all the other trusts, is that there is no Medicaid payback for the third party. For ABLE and for the self-settled and for the pooled, there is a payback, although for the pooled trust, you do have the option, instead of Medicaid getting the money, the pooled trust can be designated to be the recipient of any funds are left over after the beneficiary dies. One last point with regarding to who funds the trust. If the person who is funding the trust may need Medicaid themselves, for example, if grandma may need nursing home care, but grandma still wants to benefit her disabled child or somebody else, there are different special needs trusts that could be established that favor establishing a trust for the benefit of a disabled child or a disabled person who is under the age of 65, and those trusts could allow both the person funding the trust, grandma in my example, as well as the grandchild who has a disability, to both receive Medicaid benefits going forward. So I will stop there.
Thanks, Morris. I think that's a great comparison amongst various tools that can be used to help an individual maintain certain types of benefits that help them be independent while still being able to save funds for their future. I appreciate the comparison. Having not being an expert in these different tools, just a couple of quick questions. Is there anything that would prohibit an individual from having both an ABLE account and any one of these three different types of special needs trusts that you described?
No. You can have an ABLE account and you can have these other accounts, and there may be different reasons for having the different accounts. Like for ABLE, for example, might be most useful if you want to accumulate earnings if you're SSI beneficiary beyond the 2,000. If the person with disabilities wants to maintain control, which is less available for these other types of trusts. If, for example, parents have set up a Uniform Trust for Minors Act account and the money becomes available to the person when they become an adult, that could immediately disqualify them for SSI because they may have more than $2,000, but if the money from the UTMA account is put into an ABLE account, assuming it's under $14,000, that could then protect those funds. So those are some examples of where the ABLE account would be particularly useful.
Gotcha. And with respect to the specific things that are within the CMS guidance that was recently released and that we kind of summarized today, do you see, for the most part, consistencies with how Medicaid treats ABLE funds in comparison to funds in these other vehicles, or are there differences? Clearly there's, with respect to the Medicaid payback provision, you noted some significant differences there. But are there other things that I described in the presentation that we found in the CMS guidance with respect specifically to Medicaid that would differentiate ABLE from these other tools?
No, actually, I think ABLE, well, let me say that one difference between ABLE and the others is that ABLE is actually a tax law, and so there's sort of a different orientation in the regulations because it's a tax law than the Medicaid and Social Security laws which control the other special needs trusts. But in general, whatever can be used for the other trusts can be used through ABLE and vice versa. There is one quirk, however, which relates to paying for housing. So SSI is supposed to pay for housing, and if funds are used other than SSI to pay for housing, that could affect the recipient's ability to get the full SSI check. There may be a reduction of a third of the SSI check because funds other than SSI are being used to pay for housing. However, if these funds that are used to supplement the money that from SSI used to pay for housing are funneled through an ABLE account and the ABLE account pays for housing, then there may not be that one-third reduction. And that's one example of where the ABLE account might be actually more useful than some of these other things in that one situation.
Gotcha. Okay. Thank you, Morris. We appreciate that. I'm going to have some probably further questions here in a little bit when we move on to the panelist section. But before we start to dive into questions, both that are going to be proposed to our panelists, and we're going to be taking some questions that you all have submitted out there, I just briefly want to go and say a couple words about the ABLE National Resource Center. The ABLE National Resource Center is a collaborative whose supporters share the goal of accelerating the design and availability of ABLE accounts for the benefit of individuals with disabilities and their families. We bring together the investment, support, and resources of the country's largest and most influential national disability organizations, of which we're collaborative of over 25 national disability-related organizations working together to make sure that ABLE succeeds. So for more information, whether it be about kind of some of those ABLE basics that Marty went over, or if you're interested in other aspects about where programs are with respect to their development, or short videos on different aspects about ABLE, or a summary of some of the things that we've been going over today, I would encourage folks to go to our website at www.ablenrc.org. Okay, now that we've gotten past that little plug, I do want to ask a few different questions, and I also want to introduce our third panelist, Kathleen McGrath, who is the founder of KF McGrath, a firm providing legal and consulting services with the goal of advancing 529 college savings and ABLE programs. And she's going to be an additional person of expertise to help us answer some of these questions and facilitate our conversation now that we're in the panel section. But I wanted to start off with something pretty basic, and I want to pose this question to Marty. We're talking about how important this CMS guidance is to people with disabilities who are ABLE account owners, because they want to make sure that they can maintain their eligibility for Medicaid. But we've never really answered the question, at least not on this webinar. Why is that so important? What does Medicaid mean to people with disabilities, and why is it so important that they understand how to use these funds as to not put themselves in jeopardy of losing this particular benefit?
Thanks, Chris. I think the thing that most people think of is the health care aspects of Medicaid, but what's also important is that the Medicaid program pays for the vast majority of long-term supports and services to people with disabilities, particularly adults, in our country. And it looks different in every state. It goes by different names in every state, but the long-term LTSS, as we shorthand it, is basically paid for through the Medicaid program, and that covers home and community-based services. It also covers an enormous amount of the employment-based supports to people And it does cover a lot of supports to children at home still as they're growing up. The Medicaid program is vital to people with disabilities. So I know that many people, as we've talked about the ABLE accounts around the country, have, many families have been very interested in it, but they've been very nervous about it because they weren't sure. Nobody wants to go, make a mistake with the SSI program rules and do anything to disturb the SSI and Medicaid eligibility that a family member has or that they themselves have. And so having the Social Security Administration come out with its POMs, which are very consistent with what the Medicaid folks have come out with at CMS for this state Medicaid director letter. However, the POMs are not written in as clear a narrative form as this letter is, but they are they're written more for the staff at the Social Security Administration. If you're presented with this, this is how you handle the case, and it's more directive to internal systems, procedures. That's what it's all about. Programs, operations, manuals, systems is what POM stands for. So having something that is readable and that explains how this works, and that, in fact, some of the things that people have been told can be done and believe they need to be able to do, and it says on paper to the state Medicaid agencies, this is what you are supposed to do, is actually quite helpful. Okay. Along with the fact that the IRS has said, go ahead, go forth, believe in the ABLE program, and if anything changes in the future, we'll give you time to change your program beyond that point. So I think the stars are lining up to make it possible for people to feel comfortable when you have the big programs like SSI and Medicaid. There isn't the same concern about the assets and resources in the other Social Security programs that you have with the SSI program. So,
gotcha. Thank you, Marty. And you did mention, and I would certainly agree with that, there have been other pieces of guidance about ABLE from other federal agencies and departments, one of which is the POMs, of which, many of us have read, and it is much more difficult to read because it really is targeting a different audience, as you described, more so than the CMS letter, which I think is much more easy in terms of the narrative. However, there are certain phrases that are in the CMS letter that I wanted to get some clarification on, and maybe Morris, you'd be best to answer this question. For those individuals who have or will end up reading the actual language in the letter, Medicaid beneficiaries are often divided into different types of categories, as we can see through the letter, many times described as MAGI versus non-MAGI versus SSI. Could you tell us about these so that people who are reading the guidance can identify what parts of the guidance relate to them specifically or their situation as their Medicaid beneficiaries? Oh, Morris, you might be on mute. Oh, well, there we go. Morris, you should be on now.
Can you hear me? Can you hear me?
There you go.
Okay.
Yep,
so
go ahead.
think of these three programs, MAGI, non-MAGI, and SSI as like three silos. And they are sort of different types of public benefits, although they are very close cousins to each other. So, and it also relates to the different portals that one can qualify for Medicaid, because you can qualify for Medicaid if you're getting SSI, you can qualify for Medicaid on your own, or you can qualify for Medicaid for certain purposes under the Affordable Care Act. So the MAGI relates to qualifying for Medicaid through the Affordable Care Act or Obamacare, because when the Affordable Care Act was passed, it created a new way for people to qualify for Medicaid to get health benefits. And I emphasize health benefits because in the world of Medicaid, there's a big distinction between regular health benefits, like what a doctor and a hospital provide, and long-term services and supports, which generally what people with disabilities or the elderly need through the Medicaid program. So what this letter is saying is that if you qualified for Medicaid under the MAGI portal, which means that if the only way you're on Medicaid is because you are getting it through the Affordable Care Act, which just looks at income and doesn't really look at assets, that doesn't give you a backdoor to get long-term services and supports, which is what Medicaid also provides. If, when they're talking about non-managing Medicaid, that is qualifying for Medicaid through the normal Medicaid application process and not getting it through the Affordable Care Act. And then SSI is qualifying for the Supplemental Security Income Program administered by the Social Security Administration, and you, in many states, but not all, you automatically get Medicaid when you qualify for SSI. And the rules are somewhat different depending on which portal you're using to get the Medicaid benefit.
Gotcha. Thank you for clearing that up. I know that at least throughout the letter, they're typically treated the same, but often they have different paragraphs related to those different portals as you described, and I didn't want that tripping individuals up, and I wanted to make sure they understood which sections pertain to them as Medicaid beneficiaries. We've spent some time, I know, during this conversation talking about the Medicaid payback provision, and I know that we've mentioned that there are some states that have elected to try and get around that, one of which is Pennsylvania. And this question goes to Kathleen, who is a representative from Pennsylvania. I understand that some states, including Pennsylvania, have tried to get around the Medicaid payback provision for their residents. Could you tell me a little bit about this, and to what extent do you think this has been successful?
Sure, thank you. One of the reasons when Pennsylvania was looking at passing its law, we talked to a lot of families, and families were very, very concerned about the Medicaid payback. People were saying, I'm not going to put money in an ABLE account if my money is going to go back to the government when the beneficiary passes away. And so we thought that this was a really negative thing for ABLE accounts, and that it would stop them from thriving. So Pennsylvania's law, we wrote in a provision that prohibited the state Medicaid agency from filing a claim against an ABLE account or the proceeds of an ABLE account. So our Medicaid agency said, no, I'm not sure you can do this, because they thought that the Medicaid, the ABLE statute required the state to file a claim. So we went to CMS essentially, and CMS agreed that a state agency is not required to file a claim against an ABLE account. There is no federal law that requires the state to file for payback from an ABLE account. So Pennsylvania's law that said, no state agency, you're not going to do that, prevailed. And our state agency is not permitted to file a claim. However, the piece of our law that said you can't go against the proceeds, which was meant to protect it when it went to the estate, was superseded by the federal law, which mandates that a state does go after the estate. Now, what did we win? We won a lot, because if a state files against an ABLE account, which they may do but they're not required to do, then what they can get a payback on is all medical assistance in Pennsylvania, that's what it's called, but Medicaid, that was paid during the time the beneficiary had an ABLE account. So if you opened an ABLE account for your child when he was 2 or 3 and he passes away at 40 and he was getting Medicaid all that time, that entire amount would be subject to payback if you go under the ABLE Act. However, Pennsylvania can't do that, but Pennsylvania must go after, as all states must, the estate, but only when the deceased is 55 or older, and then only for the benefits provided after age 55. So it does do a lot to protect the ABLE account from being subject to payback, but it's not protected completely. So, you know, we're looking at whether or not we need to try to do an amendment to the federal law to allow states the discretion to protect the ABLE account even in the 55-year-old situation. And I think the problem is highlighted by what Morris showed us, in that if it's a third-party trust, it's not subject to Medicaid payback. If it's a self-funded trust, it is. But what we have here with ABLE is a combination of the two. So mom and dad and grandma and grandpa can put money into the account. If they use a third-party trust, it wouldn't be subject to payback. But the individual with disabilities, him or herself, can also put money in. And if they had established a trust for their own money, it would. So the problem is we've got these two different kinds of incomes to the trust merged. So we feel very strongly that this prohibition will discourage people from putting significant money in a beneficiary's account, not the beneficiary, him or herself, but mom or dad. So Pennsylvania did what it could, and Pennsylvania was the first. We have Oregon, who has done a similar law, and I believe California, and many other states are looking at changing their laws to protect the accounts as much as they can from payback.
Thank you, Kathleen. Just to take we have a few minutes. I'm going to take a couple questions from the folks that have submitted them through the online portal. A couple are asking about transfers from a pooled trust into an ABLE account, and I can read directly from the letter, which states that states should disregard as income a distribution from a special needs trust or pooled trust that is deposited into an ABLE account of the special needs trust or pooled trust beneficiary. So that confirms that that would be allowed. Another question says, can funds in a 529 college savings account be transferred into an ABLE account? Currently, not without paying applicable tax consequences. So you would have to liquidate that 529 college savings account, pay the tax consequences as a result of an unqualified disbursement for that program. At that point, you could then put the remainder into an ABLE account, provided that it does not go over the annual cap, which again, right now for the year 2017 is $14,000, which will be increased to $15,000 for the 2018 tax year.
Chris, if I may say
that is one of the laws that you and other advocates are working to change to allow more portability between 529 and 529A or ABLE account.
That's true. That is a good point. So there are 3 pieces of legislation that have been filed in the 115th Congress, one of which would allow a clean transfer from a 529 college savings account into an ABLE account, but that would still be subject to the annual contribution limit, which again in 2017 is $14,000, in 2015 will be $15,000.
Chris, also to add to that, if you're transferring it from a 529, if you're liquidating your 529 and putting it into an ABLE account, it would be because your child is disabled. While you do have to pay taxes, you do not have to pay the 10% tax penalty in that situation.
Okay, well, that is very good to know. Thank you, Kathleen. Okay, with that, I think we are out of time. I just wanted to quickly let people know that we've announced as of yesterday the ABLE National Resource Center will be hosting a congressional briefing on the ABLE Act with the purpose of providing ABLE stakeholders and congressional staff and members with a progress report in terms of implementation of the ABLE Act, and to have a discussion about potential legislative proposals, including the one that we just talked about that would allow for a rollover from a 529 to a 529 college savings account to an ABLE account, including other issues. So the information is up there. The briefing is December 4th in the morning. You can go to the ABLE National Resource Center for more instructions on how to RSVP. And with that, I want to thank everybody for contributing their time and talents to this conversation. and keep a lookout on the ABLE National Resource Center website and social media for upcoming webinars on other topics. Thank you very much.